From your perspective, what at the moment would be wrong with trying to pick apart Section 230 as it stands?
Well, I think it's important to differentiate between what Section 230 does, which is really provide a kind of a liability routing mechanism. It means that if I go onto Facebook and I say Bob's a crook, Bob can sue me for defamation, but he can't sue Facebook. And the reason why we have Section 230 is to ensure that Facebook can continue to operate and allow those user comments. But that's not really the heart of what was being considered today. What's being considered today is when you go on to say Spotify and a song is recommended, or you put something in your Amazon shopping cart and another product is recommended, or if you go to Google search results and you get those recommendations, do those recommendations, algorithmically driven, do those have 230 protection? That's really what the court was grappling with today. And I think there was a lot of discussion about whether it's possible to separate those algorithmic recommendations from the content itself and from the value that those services provide to consumers in the first place.
Adam, the Chamber of Progress is essentially a trade group, right? And I think it's worth pointing out that you represent the technology companies. I would say that's fair. But one of the things I continually hear out here in Silicon Valley, at least, is actually Section 230 protects the user. And that doesn't seem to be a point of consideration right now.
I think that's absolutely right. And actually, even I would rewind a step, which is that I think that the fact is if Section 230 were reformed, the reality is that the big companies, the Googles and the Facebooks, would probably be okay because they have armies of lawyers. They could, tie up cases in litigation. It's a lot of times the small services. Clubhouse emerged on the scene during the pandemic, and Section 230 is really critical for a site like that because it can start providing user-generated content and not have to worry about liability protection. That is a point that was made in court today. But I agree with you, it also protects the users. And I think this is not well misunderstood because Section 230 becomes almost a political football, particularly with respect to Democrats and Republicans using it as a little bit of a tool. But if you got rid of that liability protection, I think you would force platforms to choose between being, say, Disneyland, right, which is sort of a sanitized environment where nothing was allowed, or a wasteland where services were disincentivized to look for that content. And that was also a point that came up in court today.
I think one of the justices made the point that the panel of justices are not the sort of definitive experts on the internet, and that comment elicited a laugh from those in attendance. You represent the tech companies. Is it the Supreme Court that should be considering this? Is it even the right place to have this conversation?
I have to say, I and I think a lot of others went in today pretty nervous about why the Supreme Court would be taking this case, whether it was a sign that they were prepared to blow up Section 230. Walking out of the arguments, frankly, I think what I heard was a lot of acknowledgement from justices about the benefits of Section 230 for the economy, for user-generated content platforms, for consumers. And so I don't think that's as likely now as I was worried about at the beginning of the day. There's still a possibility that they could say, well, okay, maybe certain types of content recommendations don't have as much protection. And I do think that could have downstream stakes, not just for the big companies, but for small companies and for consumers as well.
Certain types like what, Adam?
Well, so as I said, I think Section 230 is not even, one of the things that it's a pro-competition law, right? Because it allows new social networks to emerge, right? And not have to have the armies of lawyers like Facebook and Google do. That's really important. But I also think that the fact that the issue here was about algorithmic recommendations. And what you saw the justices grappling with was, it's really hard to look at a service like Google Search and say, like, okay, it's all algorithmic recommendations, right? One of the things there was a lot of discussion about was neutrality. There's a case where there was a statement of applied neutrality. But even Justice Gorsuch, who would be someone who's somewhat critical of Section 230, said, when I really think about it, no algorithm is neutral. All algorithms are trying to highlight and privilege certain types of content, maybe relevant content, maybe high quality content. And so it's really hard to say that there should be any kind of neutrality test applied to the algorithms. And I think it was really interesting to see the Supreme Court kind of grapple real time with a lot of these concepts.
I mean, push us towards tomorrow, because then it's Twitter's time in the spotlight. And of course, that is more around how broadly you can read into the anti-terrorism act in some way. This, again, sadly involves death by terrorism, but Twitter's role in not taking down some content. Is this some sort of way in which the overall Supreme Court might find an off-ramp in some way?
Well, Emily talked about that. A lot of people have speculated about that, and I think that is a very strong possibility. I think one of the things that's interesting about the arguments today around this case were you kind of wondered why the Supreme Court took this case, right? Because, you even had, I think, again, there were a lot of people who thought, well, there were justices like Justice Thomas who were pretty critical and who basically have said in previous decisions, will bring us more 230 cases because we kind of want to take a fresh look at 230. But by the tenor of their questions, many of those conservative justices were sort of asking, why are we even here? And so I do think it was really an interesting signal of, I think, the justices' interest in looking at 230. They spent 3 hours on this, as Emily said. That's really unusual. It's about twice as long as they were supposed to spend. I don't think tomorrow's case will be quite as lengthy because it's a much narrower statute, this anti-terrorism statute that's a question, and I think a much narrower question.